Nnamdi Kanu, the detained leader of the Indigenous People of Biafra, has informed the Federal High Court in Abuja of his readiness to begin his defense on October 24, 2025, as directed by the court order from October 16, 2015. Kanu plans to call 23 witnesses, including former Defense Minister General Theophilus Danjuma, retired, former Chief of Army Staff General Tukur Buratai, retired, as well as Governor Babajide Sanwo-Olu and Hope Uzodinma. He also listed current Minister of the Federal Capital Territory Administration and Works, Nyesom Wike, and David Umahi, amongst others. The IPOB leader divided his witnesses into ordinary, but material and vital and compellable, the latter to be summoned under Section 232 of the Evidence Act 2011. This development follows protests led by Omoyele Sowore demanding Kanu's release, alongside a motion challenging court's jurisdiction and a medical report declaring him fit for trial. The court also remanded Kanu's special counsel, Aloy Ejimakor, and others protesting his trial to Kuje Correctional Center, with the next hearing set for October 24th. Joining us now is lawyer and public affairs analyst Tonye Jaja. He joins me live from Lesotho for more on this. Tonye, it's good to have you on the news. I mean, what do you perceive as Nnamdi Kanu's choosing to lead his own defense and the 23 key witnesses that he has lined up? What do you feel will be the outcome from the defense?
Hello, I didn't get that question.
I was asking, what do you perceive as Nnamdi Kanu choosing to lead his own defense and the 23 key witnesses that he has lined up? How do you feel this will play out, or the outcome will be for the defense?
Well, he has legal grounds to challenge. He said jurisdiction. So jurisdiction is very vital, because remember, he came to Nigeria by rendition. Rendition is the legal, forceful carrying of someone by the government or any other person. The legally accepted method to have brought him back was extradition. Extradition is the legal way of bringing somebody to stand trial. So the government erred by using illegal means. Now, his calling of witnesses, material witnesses, like the former Attorney General of the Federation, Malami, is on point, because Malami was the person, as the lawyer for the federal government, the chief legal officer, when he wanted to bring back Adoki. Adoki was also a former minister of justice. Malami applied the legally correct method. He applied to Interpol. Interpol brought back Adoki from Dubai. Adoki had been summoned earlier. He refused to come. He said, I am doing my master's in the Netherlands or Switzerland, wherever. He refused. But Malami applied to Interpol, extradition proceedings, and Adoki was brought back to Nigeria to stand trial by the EFCC. So that's the legally accepted method. But in the case of Kanu, he used rendition. Rendition is illegal. So if Kanu raises that as jurisdiction, that the court does not have jurisdiction to try someone who has been brought by rendition, his lawyers are right to raise that objection.
So how would the inclusion of these witnesses, Wike, for example, or the former defense minister and others, have on the trial?
Ideally, if we follow the law, if the judge is to follow the law, he's supposed to say, I do not have jurisdiction to try this case because of the rendition that was used to bring Kanu back. That's the law. The way the law works, you have to deal with issues of jurisdiction first. And if a judge finds that he has no jurisdiction, then there's no trial. Now, I don't know the role that Wike has played, but I know that Malami was Minister of Justice, and he played a role because he charged Kanu when Kanu was brought. And the process of bringing Kanu is illegal. So a court in Kenya has even held that Kanu was brought back by rendition, which is illegal. The proper means to bring him back was extradition, which was not applied.
Right. So let's look at the legal meaning of and implications of categorizing these witnesses as ordinary but material and vital and compellable under Section 232 of the Evidence Act 2011. Just help us understand what the implications and what these meanings are and what they mean, actually.
Okay, when you say compellable, that means they may not of their own free will come to court. So the court has to compel them. A subpoena has to be issued to bring them to court. For example, someone like Malami, I don't think he would voluntarily want to come to court. So you have to bring him as a compellable witness. A subpoena has to be issued against Malami to drag him to court. Then there are those who voluntarily would issue statements in support of Kanu. For example, Senator Abaribe, who stood as shorty for Kanu in the first time, he is such a witness. He will voluntarily give statements in support of Kanu. So that's the category of witnesses.
All right. Tonye, I must say thank you for taking out the time to join us. Tonye Jaja there, giving us a bit of insight all the way from Lesotho as Nnamdi Kanu's trial is about to get to the defense phase, and Nnamdi Kanu will be leading his defense.